Good afternoon. Welcome into another edition of Legal Access. We get together each and every Thursday at this time to give you, allow you access into different aspects of the law. Today we're going to be talking about criminal law. Now, criminal law sounds very ominous when you just listen to the words, but we're talking about anything from a drug arrest to DUIs to assault, simple assaults, and things like that. So if you have any questions about that or about plea bargains, trials, or the court system in general, today is the day to get your calls in. The phone number's on your screen, 843-848-8080. We'll answer those questions for you. On the panel to answer those questions for you, to my left, first of all, from the Solicitor's Office, Josh Holford.
Hey, thanks for having me,
Also,
Dave.
welcome into Defense Attorney Billy Monkton.
Good to see you again, Dave.
And Billy, in addition to criminal defense, what do you guys work with at your firm?
Do a lot of personal injury work, so personal injury and criminal defense.
And also to your left, Defense Attorney Kirk Truslow.
Yep.
And Kirk, in addition to, criminal defense, what do you guys work with?
That's all we do.
Okay.
Maybe I should be doing some personal injury. I don't know. But that's what we do.
All right, again, the phone lines are open. If you have any questions about criminal law, today is the day to get those questions answered. And don't be shy, give us a call on that phone number. Let's ask you just some open-ended questions here to start things off. Now, if you guys were like governor for the day, God forbid, but if you were, and you had the power to change anything about the criminal law system in the state of South Carolina, what's the one thing that you think needs to be fixed?
I would say the bond changes that were made. And there's probably more important things to change, but that's the first one that comes to mind for me, is that it's very difficult now to be on bond and then get arrested again and get out. And the jails are overcrowded. And I would take that away and give the discretion back to the judge and not require him to have to set a particularly high bond by law.
I think if I could change everything, and it would be time limits. I wish we could do things faster. Josh and I got a case right now, and we're just talking about it. Due to the large numbers of cases we have, although Josh and I are ready to resolve it one way or the other through a bond hearing, a plea, or whatever, you may have to wait several months just to get a court time. It's just because we don't have enough court. We don't have enough judges. It's just that Horry County has such a volume of cases because we're a tourist destination that you just can't get the court time to really timely move cases. So I would say timeliness, which goes along with Kurt's issue with the bond hearings, getting to court, because if you're out on bond, you get arrested, the only person can set it now in a lot of cases is a circuit court judge. Right. But it may take you 6 weeks to get in front of a circuit court judge.
Mm.
Yeah, I think going along with that, the ability to get into court more frequently. And it's really limited by the number of judges, the amount of court time that we get from court administration, from Columbia. We'll have a couple weeks, but I mean, we have work to do that could take every single day of every month. I think in addition to some of the suggestions would be to open up, if I could do it, I would open up what a magistrate judge could hear. They can only hear offenses that carry up to 30 days. In some special circumstances, we allow them to hear something that carries up to a year, but some of these misdemeanors carry 3 years. Well, they can resolve of those types of cases too, I would think, pretty effectively if they were allowed to do.
Well, out of 52 weeks of the year, we only have 26 weeks where we have court. I mean, obviously, would more judges help that, or is that just...
More judges, more court reporters are needed though then, and more staff, but there's definitely a limitation based on the number of judges, the number of court reporters that are assigned to them, and the number of weeks that they're actually able to hold court, because the circuit court judges are holding court here, but they're also holding it in the 46 other counties. And so the ability to have that amount of staff present and available is necessary.
With only a limited time to go before a judge, we talked before we went on the air, you said there were a lot of pleas this past week. Obviously, if you have a ton of cases, which Horry County does in the course of a year, and you've only got a limited time to get before a judge, plea bargains probably the biggest way that you get most of these cases settled.
Absolutely, and this is something the solicitor's office deals with. Victims don't necessarily like the word plea. They think someone's getting off or getting a lighter sentence. But it's necessary to resolve cases in an efficient manner. That is when the state and the defense come to some type of agreement about what what's going to happen with the case. And that happens in 99% of them. Just the pure numbers require that. If you have 5,000 to 6,000 people getting arrested in the county every single year, and you have 26 trials that you could do in a year
Right.
based on the terms of court, do the math.
Right.
You have to resolve them in another way. And it's beneficial to the victims. It's beneficial to the police. It's beneficial when someone accepts responsibility and says, you don't have to take me to trial. I admit I'm guilty.
And since plea bargains are pretty much going to be on the table for, do defense attorneys take, I don't want to say take advantage of that, but do you use that to the advantage of the persons you're representing?
I think from my perspective, if I'm working on a plea with Josh, as opposed to going to trial, when you're working on a plea bargain or some kind of resolution of the case that everybody can agree to, what I tell my clients is, hey, we're in control of the case right now. Not that we dictate what happens, but you know your outcome. If you go to trial, you don't know your outcome. You could walk out of the courtroom, or
Right.
in most cases, you're going to get a sentence on the high end of the range where you can negotiate something out where you're going to jail, but you're going to jail for a limited amount of time or special conditions that everybody's kind of worked out. You go to trial, you have no say-so.
Right. Our phone number is on your screen. Give us a call if you have any questions about criminal law or the jury or the court system in general. 848-8080 is our phone number. We've got Joe in Myrtle Beach on with us right now. Hi, thanks for hanging on. What's your question for the panel today?
Yes, I have a friend that's been arrested twice for drunk driving in the last 30 days. What kind of penalties is he looking at? 2 drunk driving charges, miscellaneous ID. That's the big one.
One of the big issues you have with DUIs are the collateral consequences. So a DUI first can carry up to 30 days or a fine. It doesn't sound that harsh, but what they've added to that is you've got alcohol and drug safety awareness classes that you have to take that last for 8 weeks or more. You have to have a special financial responsibility insurance. You have a license suspension. And now for any DUI, you have to have an ignition interlock device placed in your car and pay for and maintain that. And that can get pretty pricey just in order to be able to drive. If your friend has 2 DUIs, depending on how it's handled, should be handled appropriately where this doesn't happen, but he's potentially looking at a DUI first offense and a second offense. If he were convicted of the first one, the subsequent one would be a second offense, and the penalties, all the other collateral consequences that go along with it do, but the penalties as well go up at that point.
All right, Joe, hopefully that answers your question. If you have got a question like Joe, make sure and give us a call. The phone lines are open. Still got plenty of time to get in, more than 20 minutes. Phone number is on the screen there. It's 843-848-8080, as criminal law is our topic here today on Legal Access. Going to take a quick little break. When we get back, we'll talk more about criminal law and we'll answer your questions as well. It's Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. If you have any questions about criminal law, that is our topic here today. If you want to know about drug offenses, DUIs, or maybe the criminal law system in general, today is the day to get those questions answered. Phone number is 843-848-8080. Here on the panel to answer those questions for you from the solicitor's office, it's Josh Holford, also defense attorney Billy Monkton, and defense attorney Kirk Truslow as well. I'm Dave Priest, but that doesn't matter. I'm just here to answer your questions, ask the questions. All right. As far as like general stuff is concerned, we asked at the beginning of this what you would change within the criminal law system. As far as reality versus what you see on TV and the movies, I know you guys have watched a lot of shows that are, courtroom based. What's the thing whenever you watch TV or movies that makes you roll your eyes the most? I mean, obviously the timing. It's like, okay, people are in front of a judge in 2 days after they get arrested. Besides timing, what are some of the things that you see on TV or movies that make you roll your eyes and say, yeah, it's not even close to reality?
I think the biggest thing I see is how defense lawyers or prosecutors on TV treat the judges. If that were to happen in our court system, after about the second time, a deputy be taking the
Yeah.
lawyer into custody and they'd be going in another room. Our court system just doesn't tolerate rudeness to litigants or judges. Although on TV you see that a lot, you'd be cautioned once, and then
Yeah.
after that something drastic would happen, and it would not be good for the person who did it.
Except for my cousin Vinny, who was sent to jail several
Yeah,
times.
he got sent to jail.
Yeah.
I think one of the other things that TV does is we see what we call the CSI effect.
Yeah.
So people watch the show, the CSI, and they think, man, there's fingerprints everywhere, there's
Yeah.
DNA on everything, and they expect that as a jury
Right.
sometimes. Why didn't they do this? How couldn't they enhance that video to show the license plate exactly? Some of that stuff just
Right.
doesn't exist in the real world.
Speaking of juries, when you guys go into a courtroom, you guys have a plan in your head of how you want the trial to go. As you're talking to the jury and trying to make your case, do you try to read the jury? And when do you read the jury and know that you need to shift gears and go in a different direction?
If they're sleeping, you definitely want to do something different. No, but really, I try not to do that. I try to just stick with my theme and stick with what I've gone with and all the way through. There are times, because it's hard to read a jury. You can look at them and you can think that they're nodding their head for you and they're really thinking that they're nodding their head against you. It's a difficult thing to try to read somebody's mind
Yeah.
for me.
I've literally had people sit like this and scowl at me the whole trial and find out after jury deliberations they were the one arguing the most for my client. So I think you can get caught up, unless you're asleep, I think you can get caught up in trying to be too much about reading a jury. I think you got to try your case. Most juries, they'll tell you after the fact if you talk to them. The facts are either there or not. They're going to tell you. I think the gamesmanship, if you try and get too cute with a jury, they're going to hold it against you.
Yeah, I think what's most important when it comes to juries like that is to make sure that they can hear what you're saying. And so
Right.
not necessarily reading what they're thinking or how they're following along, but are they hearing what people are saying? And
Right.
if you can pick up like they're trying to lean in, maybe speak up or something like that, or move out of the way if they can't see what you're presenting. But I think that's mostly what I would do with juries and trying to gauge
Yeah.
the response they're giving.
Kind of the same thing with juries. I mean, people say, well, if they're only out for a half hour before they come back with the verdict, it means this, or if it's out for 3 days, it means that. Does any of that hold water?
I think it depends on the case. If I think I got a really good case as a defense lawyer and have made my point, I think a quick verdict's going to be good for me. Normally, if you're trying a very serious case where there's a lot of evidence, a defense lawyer, a quick verdict's usually bad. If it's a simple case, a DUI or something real simple, a quick verdict can be really good for the defense. But the more complicated the case, a quick verdict is normally bad for the defense.
Yeah, I agree with that.
And the same thing about juries when they come back from the jury room. If they say, well, if they're looking at you or if they're looking away, that usually means one thing or the other.
I do watch that. I do. I can't help but do that when they walk back in with the verdict, whether or not and I've had them walk in and some of them are crying, some of them are smiling, some of them are looking at you, some of them look at the floor, some of them look at the prosecutor. And
I
'cause
think the
that-
majority of them don't want to look at you at all.
Right.
Yeah,
I mean,
yeah,
it's
yeah.
like they're avoiding eye contact.
Yeah, I think so too.
And it's hard to tell sometimes because we sit right here and the defense sits right there. Are they trying to avoid me? Or are they trying to avoid them? Or,
Yeah.
they usually try and look down or just keep to themselves and not give anything away is usually what they're
Yeah,
trying to
it's
do.
almost a poker face when
Yeah.
they come back in. They don't want to upset anybody, I think. It's a tough thing when they're back there and have to make a decision on some of the cases we try.
Our phone number's on your screen, 843-848-8080. If you have any questions about criminal law or the legal system in general, we have Danette in Longs with us right now. Danette, thanks for holding on. What's your question for the panel today?
Had a warrant placed out on her for unlawful communication, and I was trying to see if that's a misdemeanor or does she need a lawyer when she goes to court? How would that play out?
What was the charge for again?
Sounded like unlawful communication.
Okay.
Probably a
Yeah, some
telephone.
text. Yeah,
charge.
it was some sent over messenger, a threat, and then what led up to it was my daughter's grandfather was abused by that other family, his wife and her family, and so my daughter apparently called them and made some threats, and so they filed a warrant, placed a warrant out on her. And so I was trying to see whether the charge is a misdemeanor or what legal ramifications can occur from this.
You want to take it?
I think technically it's a misdemeanor if I'm not mistaken. I think it carries a year or less, maybe way less, but no more than that, which makes it a misdemeanor. But you know, any criminal case can be serious, and it's appropriate to seek counsel, at least consult with an attorney. And if it's in a particular courtroom, you would have the right to get an attorney appointed if you couldn't afford one.
All right, well, hopefully that helps out. We appreciate you calling in here today to Legal Access. Let's go back to the phones right now. Go to Little River. Michelle is on with us. Hi, Michelle. Thanks for calling in today. What's your question for the panel?
My question is, what's the best way to prove a case of stalking, and is it a criminal offense?
Stalking is a criminal offense. It depends on the facts. In South Carolina, the stalking charge, you've got to have some evidence. A lot of times we see these in restraining orders where, you know, normally there are 1 or 2 police reports you got to get to go to a magistrate's court to get a restraining order. If somebody's following you around, coming to work, bothering you, you can get a restraining order which encompasses the stalking statute. But you've got to have evidence a lot of times other than just yourself for law enforcement to get involved. You know, somebody coming to your house, coming to your work, sending messages. The stalking statute and like Kurt was just talking, the harassment statute, they go hand in hand together. So it may be a case of stalking or harassment we see combined a lot together. But normally for law enforcement or a judge to take action, you've got to have evidence. It cannot be a one-term occurrence. It's got to be a pattern of time. Phone messages, messenger, following you around for no legal reason other than to be following you. And our judges are very sensitive to those issues, and so is law enforcement.
All right, Michelle, hopefully that answers your question. Appreciate you calling in here today. We're going to take another quick little break. When we get back, we'll have our final segment. So we have just under 10 minutes left. If you have any questions about criminal law, this is your time to get them in. The phone number is 843-848-8080. Call us and we'll get you on the air here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm here on WMBF News. We're talking about criminal law today, and on our panel to answer your questions. We've still got about 10 minutes left, so give us a call right now and we'll get you on the air. We have from the Solicitor's Office, Josh Holford, also Defense Attorney Billy Monkton, and Defense Attorney Kirk Truslow. Again, we're very well equipped to answer all your questions about criminal law. And Josh, we talked already about plea bargains earlier in the show, but if you are going to be offering a plea to a defendant, I don't want to say do you get okayed, but do you go over that with the victim or the victim's family to let them know this is what you're doing?
Absolutely. There's a Victims' Bill of Rights, which the legislature has imposed, and it says that we need to communicate with them. Now, they don't have the ultimate say about what that plea offer is or what the resolution of the case is, but we definitely confer with them. We reach out to them from the very beginning. They've been in contact since bond court, and we have people dedicated in our office to deal with victims in every case.
Oh, awesome. All right, let's go back to the phones now, back to Little River. Mark is on with us. Hi, Mark. Thanks for calling in. What's your question today?
My question is, my dad was recently married to my stepmom, and she was neglecting him and put him in hospice, mistreated him, put him in a room, wasn't feeding him or nothing. So we had to go to court and get him. So now I got temporary guardianship over him, and then when I went to go get him, they had to touch him and put him in a hospice hospital, and they didn't even want to tell us where it was at. So we had to take the police over there, find out where it was at. So we go down there to get him. And now we had to go back to court, and when we went back to court, they gave me another 6 months of temporary guardianship over him. And my stepmom, you know, they had 5 life insurance policy out of me. My dad was 86. And I was just trying to find out what could I do if I wanted to press some kind of charge, because every time I talk to him, I show people the pictures, and you know they said for abuse, you know, if it was an animal, they'd be locking them up. But everybody that I try to get in contact with some kind of help, I can't get nobody. And like I said, I got pictures of how they starved them
Right.
and everything, and I just can't get no help.
All right, Mark, is that some sort of a criminal case that?
Yeah, it can be.
Go ahead.
Yeah, there definitely could be. I mean, when you're talking about neglect of a vulnerable adult or elder abuse, we
Right.
typically refer to it as. But all criminal cases arise out of a police investigation. So the police have to be contacted, they have to investigate, and then take it to a magistrate judge to determine, is there probable cause to make an arrest in this case?
Right.
And another thing, it sounds like you'd been given temporary conservatorship, which is going to have jurisdiction with the probate court. The probate court is another place you can go and talk about the abuse that may be occurring with your family member. And the probate court has the ability to contact law enforcement if they think it's something that needs to be handled. Obviously, with your situation, if somebody's treating them bad, DSS can get involved and do an investigation. There are a couple different avenues. Not knowing all the details about what's going on, I would suggest the first place to go is to probate court, because for you to get your temporary guardianship or conservatorship, that's where you had to go to begin with.
All right, Mark, well, thanks for your concern for your family member, and hopefully everything works out well for you. Yeah. I think, we don't have another call on the line. Let me go ahead and ask you guys this then. From the defense side, how would you, there are two different trials you can have. You have a bench trial, which is just in front of a judge, or you can have a jury trial, which is self-explanatory. How do you decide whether or not which one is best for your clients?
Well, I think almost in every time the jury trial is better. There are times when I've seen criminal defense lawyers have a bench trial when they had a case that was solely dispositive on a legal issue, meaning that the facts really didn't matter. The whole case was going to turn on whether a legal issue was right or wrong, which is the judge's venue even in a jury trial. But apart from that, I think you want the jury in there and have 12 people decide.
All right, also when you watch on TV, whenever you see the crime shows, whenever somebody's brought in for questioning and they say, I want a lawyer, you know, the police automatically go, oh, he's guilty, he lawyered up. I mean, what is your guys' suggestions on whether or not, if you're brought in for questioning, whether you should have a lawyer by your side?
Never say a word, ever. If they've brought you in for questioning, you're a target of some point. You don't know the system. You don't know what to say.
Right.
You're nervous, anxious. You never talk. You know, law enforcement that may have an opinion about that, but I represent law enforcement. I tell them the same thing. You don't talk unless I'm there. You know, that's the reason we're there, is to make sure you don't make a mistake or say something
Right.
you shouldn't say.
So lawyering up is not a bad thing.
No.
No.
And you could say something that's innocent, and it could just be taken out of context.
Right.
I mean, the more you talk, the more there is to play with there.
All right, well, I think we've run out of time here today. We appreciate all the calls we've had. It's been a very good show. If you missed it, sorry about that. Don't miss next week. We're going to be talking about real estate law. We've had an up and down real estate market, so we'll find out more about that next Thursday. That'll be our show, Real Estate Law. If you have any other questions, you can email us, and we'll answer them off the air. LegalAccess@WMBFnews.com. Just email us, and we'll get back in touch with you. Thanks for watching. I want to thank Josh Hulford, Billy Monkton, Kirk Truslow. I'm Dave Priest. See you again next Thursday, Real Estate Law. That'll be our topic here next Thursday on Legal Access, brought to you by the McGuire Law Firm.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal advice.